We're going to go ahead and reconvene the public hearing, and we move to the land use portion of the public hearing. It's all yours.
Good morning, Commissioners. I'm Greg Barnes with the Adams County Community and Economic Development Department. And for the sake of brevity, the first two land use cases we're going to combine into one presentation. These cases are very similar. They're Oakleaf solar projects, site 37 and 44. And both of these cases are conditional use permits, which would allow solar energy facilities in the agricultural 3 zone district. And the reason we're presenting these is because they're directly next to each other. They're located just north of East 48th Avenue and just to the west of Bowden Road. The Colorado Air and Spaceport is just a few miles to the east of the site. And a closer view of these properties shows that although they're currently vacant, there are solar uses in the area, which we'll talk about in a minute. So both of these sites would develop around 11 acres of solar energy production, and it would be located on the eastern third of the property, of both properties. Both properties are zoned agricultural 3, as I mentioned, and they're surrounded by other agricultural zones. All are agricultural 3 with the exception of the property directly to the east of the site, which is zoned to agricultural 2. That property is also used for solar. The county's comprehensive plan has designated a future land use of mixed use employment in this area. That's where the county would ultimately like to see clean industry, business parks, employment centers. However, at this time, there's not a lot of infrastructure in the area to support that development. And this is typically the future land use designated area where we'll find solar energy projects. The criteria for evaluating conditional use permits includes whether the use is acceptable for the zone district, if the request is consistent with the purpose of our development standards, as well as complying with specific performance standards for the use, if the request is harmonious and compatible to the general area, all off-site impacts have been addressed by the applicant, if the site is suitable for the use, has adequate space to support the design, and services are available to support the use. So site 37 is the southern of the two sites, and as you can see, the proposed solar energy facility would be located on the eastern portions of this property. Solar panels would be arranged in a north-south linear fashion, which would be similar to existing solar in the area as well. Site 44, which is located to the north of site 37, would have the same layout. Both facilities would be surrounded by a wildlife-friendly fence, which is made of wood and wire. Solar panels would have a maximum tilt height of 10 feet. And this image shows solar facilities that are located in the area. All of these have been approved within the last 4 to 5 years. The areas that are outlined in red are currently used for solar energy. And so that demonstrates that both of these sites would have compatibility to the surrounding area. Just a few images to show you what the site looks like. So this was taken right on the sort of southeast corner of the site 37, and it's looking in a northwesterly direction across both sites. This small barn structure is located on the northern property of the two. This is looking eastward on East 48th Avenue. And this is looking, westward, and this is looking eastward toward Bowden Road, which is off here into the distance. During the referral period for both of these properties, we notified all property owners and residents within 1,000 feet of these boundaries. We sent 13 notices in all, and we did not receive any comments on this case. We heard from several referral agencies, but none of them had objections to this request. And so at the Planning Commission hearing on August 8th, there were no members of the public there to testify. No concerns were identified by the applicant. And so the Planning Commission and staff has recommended approval of both of these conditional use permits with 8 findings of fact, 6 conditions, and 1 note. Thank you.
Okay, do we have any questions for staff from the board? Commissioner Tedesco.
Thank you, Mr. Chair. So I just have a question for staff. Is there plans in the future, because I know that we're exploding with the solar arrays in this area, do you know if there's plans from the power company to build out their infrastructure for like their substations or anything like that in that area? Because you get to a certain point with these and you're gonna have to do something. Is that in the plans? Is there something that we're seeing coming down in the future for out there?
There's nothing that I've been made aware of. There is a substation directly in this area, directly to the east of Imboden Road. So I do believe this particular area is served by a substation, but I have not heard any direction from any of the utility providers toward.
And none of
Further
these
infrastructure.
solar arrays have batteries that they store on site, do they?
Not of these. I have seen some on very, very large scale projects. Like there was one a few months ago called the Piccadilly Solar, and I believe they had a battery.
Okay, thank you very much.
Any other questions from the board for staff? Seeing none, I think some of these questions are good questions we may be able to ask the applicant. Could the applicant please come forward? State your full name and address for the record. And the floor is yours.
Good morning, Commissioners. My name is Mike McCabe. I'm a partner at Oakleaf Energy Partners. Our address is 2645 East 2nd Avenue in Denver, Colorado. And we had put together a really brief PowerPoint presentation. We can certainly walk through that, and obviously feel free to ask questions at any time. Just a brief background on Oakleaf. We've been in business since 2005. The vast majority of our projects are similar in nature to what we're proposing today. And also our customers for each of those solar projects, for the most part, are here in Colorado and represent school districts, cities, and counties, et cetera. We have some representative examples up there as well, including the airport where we've done 6 projects. And we most recently did a project of similar size, about 10 acres, in Adams County last year. So the vast majority, all the energy will go to Xcel Energy. They purchase the energy using a distribution line they've got along 48th Avenue. And then through an Xcel Energy program, we're able to resell that energy to a variety of entities who then enjoy energy savings through participation. 50%, this is unique to this project as opposed to many others around the state, 50% of all those energy savings from this project will benefit low-income organizations and families, both here in Adams County and in the metro area. So we think that we're pretty excited about that. That's a new business model for us, and we think it's going to be successful. The term of the garden is similar to the other ones that surround us. Xcel does everything in a 20-year time frame. And similar to the ones that are close by, each are 10 acres, about 5,700 panels. To give you a sense of that, it's about 400 homes each year. Each project will serve about 400 homes, or the equivalent of each year. We always do our best to be a good neighbor, and I think that's evident in all the solar projects we've done in the state and including here in Adams County.
Got it.
I
Any
think that's it.
questions for the applicant from the board? Okay, none at all. If you could please have a seat up front in case we have questions. And is there anyone from the audience, anyone signed up to speak on this matter?
No.
Okay, is there anyone from the audience who did not sign up but would still like to speak on this matter? Okay, seeing none, we're going to bring it back to the board for discussion and possible motion. And just for a point of clarification, for both of these together, do they both have 8 findings of fact, 6 conditions, and 1 note?
That is correct.
So they each have 8 findings of fact, 6 conditions, 1 note. Okay, do we have a motion?
Mr. Chair, I'd like to move that we accept both item number 1 and item number 2, item 1 being 19-601 RCU 2019-17 Oakleaf Solar 37, and item number 2 being 19-602 RCU 2019-18 Oakleaf Solar 44, with 8 findings of fact, 6 conditions, and 1 note combined.
Second.
So we have a motion and a second to approve both of these items that were just heard, and that passes 4-0. Congratulations, good luck on your project. Okay, thank you, and next up?
The next item on the agenda is the Pecos Logistics Park Metropolitan District Service Plan. This is an application for a service plan for this metropolitan district. The site is located north and west of the intersection of West 56th Avenue and Pecos Street, North Pecos Street. I-76 is located just to the north of the site. A closer view of the property shows that the property's historically been used industrial. It's currently, there's applications underway for a redevelopment of this site for an industrial park. Currently, there's a mix of zoning, although most of the properties are zoned Industrial 3. There is an active rezoning and preliminary plat application in, which would combine all of this into a single lot, and the zone change would change the designation to Industrial 2 in this area if approved. The comprehensive plan in the area is industrial, which is consistent with the proposed rezoning. As I mentioned, there's two applications with the ultimate plan for this to be an industrial business park and employment center for the area. The proposed development is about 63 acres, and there's over 1 million square feet of industrial space proposed for this site. The anticipated assessed value in the 2024 would be almost $42 million if this project is approved. The Metropolitan District can be established through state statutes. It's a quasi-governmental entity, and it would be located on the majority of that 63 acres. So special districts are outlined in Chapter 10 of our Adams County Development Standards, and it's required that there be a description of the area to be served, a description of the facilities and services that would be served, and a financial plan, including cost and debt. In order to approve a service plan, there must be sufficient evidence that there is a projected need for these services, that the existing service is not adequate for projected needs or present needs, and that the proposed district is capable of providing an economical and sufficient service and the ability to repay any debt that is incurred. Descriptions of the services that would be allowed with this particular service plan includes maintenance of streets, traffic and safety controls, transportation services, fire safety equipment, security for the facility, and mosquito control, amongst other things. The total cost of improvements would be around $10.5 million, and the maximum debt limitation for this particular service plan would be about $20 million. The maximum mill levy would be 50, with a maximum interest rate of 18%. There would be various revenue sources to help this district survive, including the assessment of fees, rates, tolls, and penalties. In addition, the anticipated start would be around 2020 with a 20 mill levy at that time. Staff did refer this out to all agencies, municipalities, and districts within 3 miles. We did not receive any outstanding concerns noted during that referral period. And this service plan has demonstrated that there would be a projected need for the services. The existing service, it is inadequate to support the development. There's a capability of providing this service as well as repaying the debt. And this request would be consistent with an overall master plan, compliant with all county and regional and state level water quality plans, and the creation of the district could be in the best interest of the area to be served. At the Planning Commission, there were no members of the public present at the public hearing, and the Planning Commission recommended approval of this request by a 7-0 vote with 9 findings of fact and 1 condition. Thank you.
Okay, do we have questions for staff from the board? Okay, I do. So today what we're talking about is just the Metro District, not the rezone, correct?
That is correct.
So-
The rezone and the plat are currently processing with staff and will be brought to hearing at a later time.
And I don't feel comfortable making a decision on one without the other. I mean, we're talking about, I understand the need for Metro District, but would that Metro District still work with an I-1? Or is this a question that'd be better asked for the applicant?
I think perhaps we could speak to the applicant. I believe in order for the or for the plat to be approved, there has to be a demonstration that services would be available. And so the adoption of the metro district is essential prior to the plat.
Okay, could you go to the map of the surrounding area? And if you could go down to the colored map, is this the zoning map? Right there. All that yellow around it, those are homes? Those are residential, right?
It is zoned residential, but I don't believe, this may be a home here, but most of these are either used industrially or vacant.
Okay. And then you have another one of those zoning maps that kind of does a broader view? No, okay. All right. Would the applicant like to please come forward? If you could state your full name and your address for the record?
Good morning, Commissioners. My name is Tom George, and I'm an attorney with Spencer Fain LLP. Our address is 1700 Lincoln Street, Suite 2000, Denver, Colorado, 80203. With me also this morning are Matt Mitchell with Westfield Development Company and Michael Lund with Stiefel. Both are available to answer questions if you have any. We have a brief presentation. I'd like to say thank you first to county staff, in particular Mr. Barnes, for his assistance in this process and his presentation this morning. I have a few things to really just kind of highlight and reinforce a few things that Mr. Barnes had in his presentation. First slide is really just an overview of where we've been and where we are. This is your process according to your code. We started with a pre-application conference with staff, submitted a draft service plan, had internal staff review and comments that we then revised the service plan, resubmitted it. As Mr. Barnes said, it was then referred to municipalities and districts within 3-mile radius. Staff report and comments were provided. We had the Planning Commission hearing, and here we are today in step 7 and 8, the Board of County Commissioners. Another overview map. This is from the service plan to give you an idea of where this is located in the vicinity, with I-70 to the south, I-25 to the east, and I-76 to the north. Purpose and need for the district. The purpose is to serve the public improvement and service needs of the nearly 63-acre commercial and industrial use redevelopment to be known as the Pecos Logistics Park, which I'll refer to as the project. The need is that no other governmental entities, including the county, located in the immediate vicinity of the district consider it desirable, feasible, or practical to undertake the planning, design, acquisition, construction, installation, relocation, redevelopment, and financing of the public improvements needed for the project. The project is located at the northwest corner of West 56th Avenue and Pecos Street. It includes approximately 63 acres. Development will be approximately 1.1 million square feet of commercial and industrial space. The proposed use is Class A Industrial Logistics Park. It does not include any residential property within the project. And I note that all development plans will be subject to county review and approval. These next 3 slides are renderings of what the project will look like when it's completed. The major public improvements and services to be provided by the district are as follows: water, sanitary sewer, streets, traffic and safety controls, and transportation, and stormwater management. And I do want to note for your benefit that the water and sanitary sewer improvements will be the infrastructure only, not the service itself. Water service will be provided by Denver Water, and sanitary sewer by Berkeley Water and Sanitation District. These next 2 images are pulled from the service plan as part of the utilities maps that are there. This shows the water and sewer utilities on the site. And the next one is just to give you an overview too then of the street improvements, landscaping improvements, and the top left, because the blue is the detention pond that will be necessary for the project site. Key limitations in the service plan are the following: a maximum mill levy of 50 mills. This is a combined maximum of debt service mill levy and the O&M mill levy. A debt limitation of 20 mills. Any material modifications to the service plan will require approval by the county. Construction of the public improvements are subject to requirements of the county and any other governmental entity accepting those, for example, Denver Water or Berkeley Water and Sanitation District. The district will be required to submit an annual report to the county by June 1 of each year, and the district, as a political subdivision, will be subject to all applicable laws such as the Special District Act, the Local Government Budget Law, the Audit Law, Open Meetings Law, Open Records, Election Code, and so on. Important numbers about the district are these: the proposed O&M mill levy is 5 mills. The proposed debt service mill levy is 20 mills for a combined mill levy of 25. The estimated total cost of the public improvements is approximately $10,628,000. Anticipated debt issuance will be received, the district will receive about $9,484,000 in project funds. Next steps are these. As you can see, July 25th, we were at the Planning Commission. August 27th, we're here today. Assuming approval of the service plan today, we then will submit a petition to the Adams County District Court. The court will hold a public hearing on the service plan and call an election. The organizational election will be held on November 5th of this year. Our request today is consistent with Section 32-1-2042A CRS that the Board of County Commissioners approve the service plan for the Pecos Logistics Park Metropolitan District. That concludes our presentation. We're happy to answer any questions you might have.
Do we have any questions for the applicant? I do. Today, once again, we're talking only about the Metro District. I don't, but I have some serious concerns about moving heavy industry in between Pro-Mac, Midtown neighborhoods, and Guardian Angel neighborhood. And so, since that is not the topic of today, my question is if we prove today, could you still proceed with an I-1 development as you're recommending?
I think I'll let Matt Mitchell with Westfield Development Company answer that question. And if we could, Greg, could you go back to just a couple of the renderings? I just want to kind of highlight for you too, and Matt can talk about what the site looks like today and then what it'll look like when the project's complete.
Yeah, Matt Mitchell with Westfield Development Company. Our address is 4221 Brighton Boulevard in Denver. You may recognize Westfield. We are the developer of the old Mapleton School property at 64th and Washington. And did the Hub 25 project. We're proposing a very similar project here. Largely single-load, multi-tenant industrial buildings, truck loading in the back, office in the front. To your question about I-1 zoning, so first of all, most of the site currently is I-3 zoning. There are 2 pockets of residential zoning that have single-family homes on them that were owned by Rocky Mountain Prestress, the prestressed concrete company that operates on site today. They were occupied by employees of Rocky Mountain Prestress. They are no longer occupied. We're actually going to demo those old houses eventually. And so our proposal is to lower the zoning from most of the site from I-3 to I-2 to a less intense use, but raise the 2 residential parcels to I-2 zoning. And so that is consistent with the comprehensive plan for Adams County. We are sensitive about abutting the neighborhood to the west. The standards and regulations for Adams County require a 15-foot landscape buffer zone between residential and industrial uses. We're going to actually, in our plat, provide a 15-foot landscape tract. It's going to be a minimum of 15 feet. It goes as wide as 25 feet for large stretches of it. And we're going to provide a 10-foot decorative block screen wall that should screen noise, vision of trucks, and site lighting from the neighborhood. We're also separated by Vallejo Street to all but 2 homes. And so we feel like that should adequately buffer our project from our neighbors. We did have a neighborhood meeting for our proposed rezone, and we had about 43 people show up to that meeting. I would say the general consensus is everyone's very excited to see an outdoor, dirty, heavy industrial use turned into a manicured, cohesively designed business park. And so a dirty outdoor industrial use is becoming a clean, organized indoor industrial use. We feel like that's beneficial for everyone. And so the reason we like I-2 zoning, specific to your question, it allows for a little more generous trailer parking. It allows for some limited outside storage, things that we think will be benefits to our park to be able to offer to potential users.
All right, I have more questions, but Commissioner Tedesco.
When you talk about rear loading for the trucks, which way is rear for you? Is it the highway side or is it the?
Could you pull up the map that you had earlier? That one's perfect. Is that okay, Commissioner Tedesco?
Most of these, anytime you have industrial buildings, if you can, you try to avoid north-facing docks for snow and ice buildup, and just a safety concern for users. So most of our buildings are oriented running north-south with storefront and glass line fronting Pecos Street or 56th, and trucks loading into the interior of the park where you can't see them from public right-of-way. Now, driving down 56, you will be able to see down between the long ends of buildings. We're proposing screen walls made of panels coming off the end of the building to screen some of that truck view from 56th. But when you drive down Pecos, all you will see is the storefront and glass line of the park. You will not see any loading facilities there.
And then I saw on one of the maps you have a entrance at the southern end of the property. Are they also going to be using 56th as an entrance to this property?
With a business park with almost 1.2 million square feet of industrial, we need more than one access point to allow for trucks, just for proper circulation of the park. Staff has voiced that concern as well, and we're receptive to it. We are going to provide interior signage directing truck traffic to exit to our main access point on Pecos Street to try to keep as much truck traffic off of 56 as possible. But we can't commit to not having zero trucks on 56. We need to be able to have a few come through there. And our traffic study is, as part of our submittal, would support that.
I think that's my biggest concern, is having these big trucks travel down 56th Avenue. This is a residential area. We share these neighborhoods with both the Denver side and the Adams County side. Pecos is currently a two-lane road, which has heavy congestion regardless of what time you're on there. And 56 is no different. And having these trucks and everything, I mean, you know, as much as I appreciate your view of this being an outdoor dirty facility, it did not contribute greatly to the congestion or the, you know, the flow of traffic in the neighborhood, because it was very sporadic as to what happened there. These were well-paying jobs that did a great job and built a lot of the things that you're trying to build right now, which is pre-stressed concrete. And I appreciate what they've done, but I'm also very cognizant of what we're trying to do. And although I think it's a beautiful building and it's a beautiful location, I'm really concerned about the impacts to this neighborhood and the adjoining neighborhoods as to the amount of truck traffic and the amount of traffic in general into this facility. I would really like to see a dedicated service entry, you know, not through the neighborhood. I mean, it's just that critical for me that happened.
Again, we've designed our park with our main access point on Pecos. We've requested a signal, which the county has preliminarily put into their design for Pecos, to help provide significant flow to that point so that we can have the volume of trucks come and go and not congest our park and not have to come down 56 as often. My concern is we have a park that doesn't circulate. We will not lease it. It will not be successful. That being said, we will do everything we can design-wise to focus the main flow of trucks to Pecos and not 56th. I would point out that the two parcels to our south, north of 56, are both commercial operations. Both have truck traffic coming and going from them. The property across 56 is the Iron Workers Union. They have a truck entry access as well. I mean, there is truck traffic on that stretch of 56 to date. I understand that we would be increasing that flow. I would ask that the board looks at the traffic counts proposed at full build-out of our project and our traffic study. It would demonstrate that the additional traffic counts, and I don't have the numbers readily available, but it's not a significant increase in trucks per day.
Okay, anything else, Commissioner Tedesco, at this moment?
No.
Okay. Can we go back to now their rendering of their design and the infrastructure pieces and the entrances and exits? Can we go back to can we go back to their blueprint that shows the layout? Okay, so my question for staff and the applicant, other than curb gutter sidewalk, are you widening 56th Avenue to the south?
Currently, there's 50 feet of right-of-way there today. Let's see, that's not true. There's 60 feet of right-of-way today, except for a portion that we show in parking on that westernmost building of the southern three. We're going to dedicate that 10 feet back, so it's 60 feet all the way down. There is not currently curb gutter and sidewalk on the north side of 56. We're going to provide that infrastructure. What we've talked around with Public Works is by further widening 56, we might actually encourage more truck flow on 56. And so, again, in an effort to design it such that it's not as inviting to trucks, but still safe if a truck does travel down it, we've tentatively agreed to 13-foot travel lanes on both sides while maintaining a 7-foot parking lane on the southern property line along the residential properties for on-street parking.
So we're not widening it?
No.
As much as, because I have the same concern that my colleague does, and let me tell you, like, first of all, I'm a big fan of what you guys did over at Mapleton and at Hub 25. You said it's Hub 25?
Yes, that's what we called it.
Yeah, And in those environments and with that neighborhood, it's exactly what we need. Aren't those I-1 though, or were those I-2?
I don't recall. I believe they're I2.
I thought that they were I-1. And I would like a point of clarification at some point on what those Mapleton and Hub 25 are currently zoned. If the staff can look that up while we're having this discussion. And it sounds like the future has, and this is a question for staff, in the future, after this hearing, we have a hearing for rezoning, and then what else? Or is that it?
So there's a very specific order of operations. The next hearing that will be before you will be for the preliminary plat. The rezoning cannot take place until all of it has been combined into one lot, because currently there are lots that don't meet the minimum lot size for I-2. So the preliminary plat would come first, and then the rezoning would accompany the final plat before the board.
And so the reason I ask is a lot of the concerns that I have, and I think that some of us will have, and I think the neighbors may have at some point once they realize the potential intensity of I-2 compared to I-1, is that if we wanted to have changes or additional conditions to protect the neighborhood, the next opportunity would be at the PUD, the preliminary plat, correct? Because we're still in a flux, or it's still questionable whether we could do that at the zoning stage, at least within what we're having discussions 3 weeks in a row now. Is that correct?
That sounds correct to
So
me.
if there were protection and conditions we would impose, it would be at the next hearing, correct?
That is correct.
Tom?
Commissioner Tedesco and Commissioner Odrishi, I just wanted to add that nothing in your requested approval today of this service plan approves any land use or any land use development at all. Approval of the service plan, these are just projections. The district doesn't have any control over what the developer does with the site or their proposal, because the developer's gonna come back with its plat and work through your land use process that way. That's not what you're approving today. This is just the service plan.
But I'm hearing that there's and I'll come right to Commissioner Tedesco, but I'm hearing that the potential, if this were not to be approved for I-2 and it were to remain I-1, could have an impact on values and your finances, which then would impact the Metro District. And therefore, I have concerns because I'm not sure I would bet that this would be I-2 approved. I wouldn't put, it may or may not be, I can't say that at this point, but if we are assuming that the values and the revenues are based on I-2, I would have concerns about making a decision today on this Metro District. Does that make sense?
It does. Just to clarify, and maybe we can look at the zoning map again, 70% of the site or so is I-3 currently. And so most of it is much more heavily zoned.
And to vote no on a rezone would keep it I-3 is what you're saying?
Yes.
Yeah, I understand that. Commissioner Tedesco.
Thank you, Mr. Chair. So first of all, I won't speculate on how anybody's going to vote on any of this.
Right.
I don't think that's the appropriate way to address this. I will tell you that this isn't the place where we make these decisions, but the reasoning for my pointing that out is when you move forward with this project, I don't want to hear at the end of the day, well, you never said anything. You never said you had concerns. You never pointed out the concerns that you had. The reasoning for my statements was to point that out, so in the future, after the process moves forward, and when we get to the appropriate process point, you know those questions are gonna come up. And you have time to prepare, and you have time to address those issues when they come up. Okay?
Just to be clear, those concerns are traffic impacting the neighborhood and buffering
Ingress
the
and
use
egress
from the
of the
neighborhood.
facility itself, yes,
Understood.
with the trucks. So that's why I was saying with the truck traffic, you know, I think that it's very, very legitimate that you would have car traffic on 56th. But my concern is the truck traffic on 56th and the ingress and egress of those trucks into the facility to keep the flow that you're talking about. Okay?
Understood.
And I'll tell you, my concern is the current I-3 use that we have now is still lower in impact than many of the I-2 that could happen in the future. So that's what I'm also concerned about. Now, I do think that what you're proposing is definitely the kind of thing we want to see, that kind of investment, but I'm concerned still about an increase of intensity of heavy industry next to these neighborhoods and next to these homes. And then as far as it goes to, as far as public infrastructure, I would prefer even to see that part of what the Metro District could do is provide, maybe it's a private, if you're gonna be encouraging people from one end, the west end of the lot, to exit through your property out on Pecos, is there any way to do some sort of frontage road type thing within your property that encourages people to use that property rather than 56th Avenue? And that could impact your metro district.
So that is, some of the comments we've gotten from staff is encouraging the design and the signage interior of the park to focus trucks exiting to Pecos directly. You will, when you do see our plat, you will see where we've already designed that and noted it in the plat where we plan to put the directional signage and the flow of trucks, directing it directly to Pecos. I would point out as well that Adams County is in year one of a 3-year CIP project on Pecos. That includes the flyover bridge south of 52nd. And so that ultimate condition of that road will be 2 lanes southbound, 2 lanes northbound, and a dedicated turn lane with raised median, so you can't come across traffic and except for intersections. And so that will be a much more efficient roadway. It will be a much more wide and improved roadway, and our project is going to pay for that as it, along our frontage as well. And so we'll actually be paying, in addition to the road improvement fees we'll actually be paying directly the cost of our half of that improvement along our frontage. And so hopefully that helps alleviate traffic, make it a safer condition for pedestrians where there's no sidewalk on the north side of 56 or on the west side of Pecos currently on our frontage. They will have all of that. I mean, it will improve this whole area, from a safety and traffic flow standpoint, long term.
Got it. Commissioner Tedesco, you still have a request to speak. Is there anything else you have?
No,
Okay, got that. Is there anyone else from the board who has a question for the applicant? If you could have a seat up front, and then we're going to open it up to public, but first, staff has some comments.
I would say thank you again for pointing out that we're going to hear from you. That gives us time to address it before we find out later in the game. Very helpful for us.
Yes.
Hi, good morning, Commissioners. Jen was able to look up the Hub 25 project, and we did confirm that it is I-2 zoning.
Okay. Got it. Thank you. All right. Is there anyone from the audience that is either signed up or not signed up that would like to speak on this matter? Nobody? Nobody signed up?
No.
Okay. We're going to come back to the board for discussion and/or motion. I guess my comments will be, you understand what our concerns are. Based on what you're showing for the plan, I would have concerns about the next steps. But I think that having a metro district will actually help benefit the site and the neighborhood by having some more resources to address some of those amenities like curb gutter, sidewalk, some of the other infrastructure things that I think will be good to see an improved site. That's my comment. Did you have another comment?
No, I just,
Okay. Is there anyone else who has a comment and/or a motion?
Chair, I move for PLN 2019-5 Pecos Logistics Park Metro District to be approved.
Second.
We have a motion and a second. And that motion passes 4-0. Good luck. We look forward to the next conversations.
thank you all.
Thank you.
Appreciate your time.
Okay. Next up.
Good evening, Commissioner, or good morning, Commissioners. I have an updated Metro study that I wanted to submit for the record and have some copies of that. It was just submitted yesterday by the applicant, but it would replace the market study that's in your packet. Okay. Thank you. So this morning, I'm presenting the Promontory Metro District Service Plan for numbers 1 through 5. This request is for a Metropolitan Service District Plan. And this is the aerial view of the entire area in question. It is just to the south of East 168th Avenue and just a little due north of East 160th. sandwiched between Yosemite and Havana Street. The current zoning map, the entire area is planned unit development and is bordered by additional planned unit developments as well as A1 low-density agricultural uses and residential estate, which are lots that are greater than 1 acre. And on the future land use map, the area is projected for estate residential, which are lots that are greater than 1 acre in size and a little bit more agrarian in nature. So a little bit of background, the Promontory District is comprised of 364 acres in total. 48 acres are within the district boundaries, and those are the Shook subdivision plats that 2 that have already been approved and 2 that are in progress at the moment. And then the applicant is requesting 316 acres within what's called an inclusion area that is projected for future growth of the area. And the anticipated build-out, which is not entitled by the county, I have to say this, it would require additional applications, is 444 single-family detached homes that would range in price between $550,000 and $625,000, as well as 100 multifamily units, which the home prices would start in the $375,000 range. And the estimated projection for the population is 1,621 residents. So just some of the development standards in terms of approvals for a metro district, which is what is before you today, it's outlined in Chapter 10 of the Adams County Regulations and Standards, and the applicant is required to submit a description of the area to be serviced, that they are just need to describe the proposed facilities and the services that are provided, and that they have a financial plan that outlines their cost and debt. And they and you in turn need to vote upon the findings that this is sufficient for the existing and projected need of those services, and that the existing service is inadequate for the present and projected needs of the population, and that the proposed district would provide economical and sufficient service and has the financial ability to pay back the debt. So just a little description of the promontory request for this particular Metro District Service Plan. The financing and the construction are specifically for public infrastructure and improvements, which would include water and sanitation systems, the streets, traffic controls, parks and recreation, as well as transportation, television relay, covenant control, and security services for the greater 364 acres. So the financing structure breakdown is that the maximum debt issuance that's requested is $69 million. The estimated cost of improvements is $46,294,500. And the maximum mill levy that's requested for the greater area is 50 mills, as well as an interest rate of 18%, a proposed length of the bonds of 30 years, and an operating budget of the Metro District of $100,000 within that first year. So we sent out referral comments to the following districts and agencies, and they had a few comments that were based on locations, clarifications, based on just the greater districts that fire service would provide for. Highland Acres and Water and Sanitation is having some discussions with the applicant about access to their North Water Treatment Facility, and that is something that is under discussion at the time of the plat. But it was a comment that was made throughout this application. And then Tri-County wanted additional requirements for mosquito control plans, and Excel Energy just wanted assurance that there wouldn't be any hindrances to future utilities in the greater area. And then our finance just wanted clarification, questions answered. And as of today, those questions have been answered and finance has no further comment. So a little bit of the PC update is that this was heard in front of the Planning Commission on August 8th. The Planning Commission recommended approval on a 6-1 vote, and there was no public testimony. So the staff analysis for this particular Metro District proposal is that the applicant is providing sufficient existing and projected need with this Metro District application, and that the existing service is inadequate within the greater area. The applicant is capable of providing the service and the ability to repay the debt, as well as the adequate services wouldn't be provided through the county and wouldn't be available through any other form of an agency, and that the facility and service standards are compatible with our standards, as well as complying with master plans and county, regional, and state water quality management plans, and that the creation of the district is in the best interest served of the area. So staff recommendation, along with the Planning Commission, is to recommend approval of this request with 9 findings of fact. And that concludes my presentation, and I'm available for any questions.
Any questions for staff on this matter? Nope. Okay, going back. Thank you very much. Can we have the applicant please step forward? Please state your full name and your address for the record.
Good morning, Commissioners. My name is Eve Greena. I am an attorney with White Bear, Ankley, Tanaka, and Waldron, and my address at home is 4470 South Irving Street in Sheridan, Colorado. And since this is our second hearing on a service plan today, and Libby has done such a wonderful job presenting the details of our district, in the interest of time, I just wanted to see if any of the commissioners had any questions or wanted any additional information about this particular set of districts.
Any questions for the applicant? I see none at this time, so
Okay.
if you could, feel free.
All right, just as Libby said, we have a proposed district that has initial boundaries of 48 acres, and that would be the Shook subdivisions 3 and 4. It also includes a larger inclusion area, which is a future growth area. So as those parcels become interested in joining the district, they would petition for inclusion within the district, and then the service plan provides for services for those areas as well. Commissioners have demonstrated a pretty good understanding of special districts, so I'll skip over this. We do have a multiple district structure with 5 districts, District 1 being the operating district, which would coordinate construction activities within the greater community area in the district. The overlay district would encompass all properties within any of the districts, and that would be the service district. So that district would contract with service providers to give a uniform level of service throughout the districts, all 5 of them. That would also ease and transition to resident control. And then the remaining 3 districts would be financing districts serving as the tax base. We are proposing a debt limit of $69 million and anticipate issuing 2 series of bonds. The maximum debt service mill levy would be 50 mills, and the O&M operations and maintenance mill levy would be limited to 50 mills before the imposition of a debt mill levy, and then limited to 20 mills afterwards. This slide just gives you an example of the possible tax increase for a home. If the price of the home was $625,000, then the annual tax increase that we would estimate based on the 70 mills maximum would be $3,128. This is a comparison with other recently approved metropolitan districts, just to give you an idea of where Promontory sits within the recently approved districts. And then, yeah, so if we don't have any further questions.
Commissioner Tedesco.
Mr. Chair, could I ask staff to go back to the mill levy slide?
Are you requesting the applicant mill levy slide, or?
Yes.
Okay, yes.
Yes, that one. So this isn't a question for you, this is a question for staff. Pardon my ignorance, but I did not see in your report that it was a maximum of 70 mils. I only saw that it was a maximum of 50 mils. Can you explain why yours was different?
I will defer to the applicant for the additional 20 mils that she's outlining in her presentation, but our service plan materials calculated the 50 mils.
Okay.
So,
Okay, in section 6, subsection G of the service plan, it outlines the maximum operating mill levy. So that is after the subsection C, which talks about the maximum debt mill levy. And so it talks about an aggregate mill levy before a debt service mill levy is imposed of 50 mils. And then once there is a debt mill levy imposed within the districts, then the operations mill levy is limited to 20 mils. So in total, once an operation mill levy is imposed and there is debt to be repaid, the districts could impose up to 70 mils, which would be the 50 mils for debt maximum, and then a 20 mils for operating.
So I guess my question is that I'm having a hard time with what I was presented with from staff, meshing with what you just presented to me. So I'm trying to get an explanation of staff why that wasn't included in the presentation that we saw.
I'm also going to defer to our finance team for further clarification.
Can we propose a 5-minute recess to get some information? Okay.
Yes, please, thank you.
What I'd like to do at this time is, thank you very much. We'll have some more questions. We'll follow up on this issue. Is there anyone from the audience that signed up at this time to ask questions or speak on this matter?
No.
Okay, is there anyone that has not signed up but that is in the audience that would like to speak on this particular case? If not, what I'll do, I don't see anyone. At this time, we're going to take a 5-minute recess to let some information together and allow us a quick break.
We are.
Okay, we're going to reconvene the hearing, the land use portion of the public hearing on case PLN 2019-9, Promontory Metropolitan District, numbers 1 through 5. Okay, if we could restate the question or the issue that was researched and then answer to the best of your ability where we are. And if you also need more time, we would rather have you guys make sure we're on solid ground with whatever information you provide rather than speculate, because we don't need to be rushed.
Commissioners, the question that was stated was, where is the 20 mil operating cost that was detailed in the applicant's PowerPoint presentation, in our presentation and our report? And that was a staff error. So my deepest apologies for not putting that information into either one of the report or the PowerPoint presentation. It is included as exhibit material on page 132 of your packet. So it was in the packet itself, but it was not outlined in a bulleted format from myself. So my apologies.
So how do we, this is a question for the county attorney possibly, and then I've got a colleague who I can follow up because this was a line of questioning from him. But how do we protect the record to make sure that whatever is approved today is the correct level of mills, and that we don't have a challenge in the future because of the ambiguity that was identified here?
And others feel free to jump in. I guess my thought is, as long as we are clear on the record here today, prior to any vote by the board, what mill levies we're actually looking at, because this will have multiple processes after today, including a court order and a vote, I feel like as long as you, as a board, are making a decision based on the accurate information, it's not as critical that the information presented for public consumption prior to today be accurate. I don't think I phrased that very well, but do you understand what I'm trying to say?
What I'm hearing from you, is to be absolutely clear in the maximum mill levies that are approved today, which I can imagine that the applicant appreciates in their financing as well. Commissioner Tedesco, would you like to follow up?
Mr. Chair, I would like to follow up, because if this was a oversight, a missed item for us, I'm concerned that it was a missed item for our planning commission when they recommended this on the vote that they had. And so I'm wondering if this item should not go back to the planning commission for them to reevaluate based on the information that I feel has been pertinent and maybe left out for whatever reason. I'm not confident that the recommendation by the planning commission took in all of the details, especially if this was not part of it.
Commissioner Tedesco, this very report, aside from the PC findings, was provided to the Planning Commission at the time. And the applicant did have a PowerPoint as well that outlined this material.
And again, it's not the applicant's PowerPoint that I'm questioning. It's the PowerPoint and the recommendation that came by staff to make a decision.
Okay, at this time, there's a question on the table from Commissioner Tedesco. Our system is not working, but I see that someone else has requested to speak next. But I want to first let the issue that Commissioner Tedesco brought up, rather than me trying to restate what I think he's saying, I'll just let his, I've learned my lesson on that one. Let me ask again, so what would you like to see Commissioner Tedesco done or explained?
What I would like to do is readdress this with the Planning Commission, because I don't believe that the Planning Commission either caught or was aware that this was missing from the staff report. I just want to make sure that they're fully aware of what was in there and what was presented, and aware of what the impact of this may or may not be based on that other 20 mills.
Staff?
Good morning, everyone. So I'm seeing if we can pull up the presentation. I think what I would like to just say is that the staff report is sort of a overall summary, but the exhibits that do indicate this operating levy were provided to Planning Commission, and I'd like the applicant to confirm if this is the same presentation they gave to Planning Commission. So while certainly, yes, it was an oversight to not bullet this one item out, it was in the materials, and again, the staff report serves as sort of an overall summary of what's contained in the service plan, not a line by line of that.
And before, I'm going to go to allow the applicant to finish this issue, and then we're going to go to Commissioner Henry. But I will say, we might be able to clarify this with a finding of fact as well. And that might make it more clear that what mills we have. But I would ask Commissioner Tedesco if he thinks that, I'm asking, not restating, is your concern that we have that 50 mills versus 70 mills could have an impact on future homeowners and property owners? Is that what your concern is?
Thank you for asking, Chair. My concern is that this was recommended by the Planning Commission, but it was recommended without, I believe, without full knowledge of, especially from staff, of the impact. Alls I want is reassurance that the Planning Commission is still recommending at the same level they are with that knowledge, and that they recognize that that was a mistake. I don't know how that can happen, whether they need to recall a Planning Commission meeting or if you can do it electronically. I'm not sure. I'm just asking that I would feel much better making this or moving this along, as long as I knew that the Planning Commission saw all the facts when they recommended this item.
Okay.
And if I could
Yes, please
speak to
do.
that. I did make this same presentation at the Planning Commission, and we did discuss this slide in particular and the confusion between the 50 mills for debt service as opposed to the operations mill levy. So my understanding from the Planning Commission was that they were discussing the 70 mills, and when we went to the next slide and looked at the tax increase, that was also a slide that we spent some time on and discussed the 70 mills total. So,
Mr. Chair, I'd
from
like
my
to respond.
understanding.
I appreciate your view and your perception of what happened. I'm sure that's probably the way that it happened. But for my personal assurance, I would like to reassure that or reaffirm that with our Planning Commission.
Okay.
Commissioner Henry. And we'll come back to you in a minute. Commissioner Henry's been waiting.
Yeah, while I appreciate your concerns, and I have the same concerns, Commissioner Tedesco, since it is a staff error, I have concerns at the fact that we'll be penalizing the business over something that our staff had overlooked. And since they were the Planning Commission had already seen the applicant's points, they should have been somewhat aware of what it was. But I just wanted to make sure that, like I said, my concern is penalizing the applicant over an error that our staff had made.
Okay, with the applicant, could you please state your full name and address for the record, and then feel free to contribute to the discussion.
Blair Dick-Owner with the law firm White Bear and Ankley, representing the applicant. I just wanted to add to some of what Eve said. Address is 2154 East Commons Avenue, Suite 2000, Centennial, 80122. I just wanted to add what Eve said. The Planning Commission doesn't approve staff's report. They approve the service plan. And it contains the mill levies that we've been talking about in there. As staff pointed out, not every single detail of the service plan is in staff report, yet they still approve the service plan that contains all of that. The other constraint that we have is we're trying to hit a November election. And if we have to go back to PC and then back through you again, it shoots that. We're done for the year and we don't have an election, the project doesn't go forward. So I think there's some time constraints that should also be considered when you make your decision. So,
Okay.
Thank you.
Thank you very much. Any other commissioners that have okay, I'll make a comment. If you can help us draft a 10th finding of fact that help clarify this matter. Planning Commission, in my opinion, is advisory in nature anyway. There's quite often times where we make changes to some of the facts, findings, or conditions at this level. If we were to help be very clear with the 10th finding of fact that clarifies some of the ambiguity that's been discussed today, I would feel comfortable to proceed, but that's my personal opinion. And maybe it would be that the attorney who just spoke might be able to help work with staff to figure out what that 10th finding of fact would be, or our county attorney staff could be, and then clarify that. That would be in my opinion, but if anyone else, Commissioner Tedesco, what would be your thoughts on that proposed process?
Mr. Chair, I'm okay with whatever direction this board wants to go. I'll vote accordingly. I will say that, you know, although the Planning Commission is advisory, I think they're advisory as long as they have all the facts in front of them. And I still, at this time, am not sure. I mean, I have reassurances from the applicant, and I appreciate that. And I have reassurances from the staff. I appreciate that. But I just feel like there were some information that was left out or maybe not addressed, and alls I'm asking for is that we have the Planning Commission just make a statement saying they had saw that and they recognized it and we're fine. I don't know what that looks like or if we can even do that, but if it does go to a vote today, you know, like I said, I'm gonna vote accordingly and whatever that may be.
Okay. County Manager, Mr. Gonzalez.
Yes, Commissioners, just listening to Commissioner Tedesco, Heidi and I had a brief conversation, and we think we could, if we break, we could listen to the audio of the Planning Commission to verify and kind of get that reassurance that Commissioner Tedesco is looking for, if the pleasure of the board is for us to do that. So,
Commissioner Tedesco.
So I'm fine with that. I do want to make a statement though, because there was a statement made of we shouldn't penalize you, and I'm not looking to penalize you. But I'm also not looking to penalize the constituents that may be affected by this oversight. And that's really my concern, is the ongoing issue of we have so many metro districts within our county that have extremely excessively high mill levies that they can have access to. I just want to make sure all of that information was disseminated and presented, and they understood what they were recommending. That's all I'm asking for. And if you can do that through that, I'm perfectly fine.
At this time, I believe the staff is putting together a proposed finding of fact, or would it be a note?
We're clarifying that it is a note.
Okay? And that would be part of the official record if it were to be approved, correct?
Correct.
Okay. Would you like to explain what your thoughts are?
Yes. I will read it in full, and this was just discussed with our attorney as well. The service plan being approved is the one shown in Exhibit 3.2 of the August 27th, 2019 BOCC staff report, outlining in the financial plan 50 mils for debt service and 20 mils for operations and maintenance.
Commissioner Henry, did you have something else? Okay. I think right now the question is we're back to discussion. I already opened it up to the public. Nobody was there. Did I open it up to the public yet? I think I did. Sorry. And now we're back to the board for discussion about whether we think that this note, additional note, will be enough to allow the applicant to proceed, enough for a vote, or if we want to send this back to the Planning Commission. Or take a break for 15, 20 minutes and have staff listen to the. So we have three options: proceed with the note without listening to the hearing, or proceed with a recess for 10, 15, 20 minutes to listen to the hearing and provide some assurances or not, or confirmation whether this issue was adequately addressed at the Planning Commission. Commissioner Pinter, what are your thoughts?
I make a motion to adjourn for 20 minutes. That would have us coming back at 11, let's say 11:20. That's my motion.
Okay, do we have a motion for a recess? Do we have a second?
Second.
And we have a second? Okay. Is there?
It's verbal.
It's verbal.
Commissioner Pinter,
Yes.
Yes.
Commissioner Tedesco?
Yes.
Commissioner O'Dorisio?
Yes. Okay, we're going to take a 20-minute recess, allow our staff to go listen to the public record from the Planning Commission hearing, and then report back to us on this matter. Okay, we're going to reconvene the public hearing portion, the land use portion of the public hearing. Did staff have a chance to look through the Planning Commission hearing?
Yes, both Jen Rutter and myself, Jill Jennings-Golick, did listen to the recording from the August 8th Planning Commission meeting where this service plan was presented. And the applicant presentation was very clear, and it was stated a number of times that the maximum mill levy was 70 mills, and there were no questions from the Planning Commission on that particular item of the service plan, and would be more than happy to put this recording on a jump drive and so that you all would be able to listen to it if you would like.
So I'm going to go to the individual commissioners to follow up on this, but a point of clarification for staff and the county attorney would be, it's my understanding that the Planning Commission hearing is already part of the public record and is incorporated into the public record of these hearings. Is that correct or not correct?
I would say it is definitely part of the public record. That hearing is on the website. Christie, I don't think it's, the entire hearing is incorporated into the packet for the BOCC. No.
Hi, Christy Fitch with the County Attorney's Office. So what the Planning Commission does is recommend approval. So as far as their recommendation, I believe is part of your record. But the entire hearing itself, I would not think would be part of that record.
It's part of the public record, but not the record of this
Correct.
particular that we make today.
Yep, and just for a point of clarification, that audio is also available on the Planning Commission's website, on our website.
That's right. Okay. Commissioner Tedesco?
I just had a quick question, and I know you guys probably don't want to hear this, but, so the only time it was brought up was by the applicant? It was not brought up by staff or anybody?
Correct.
Okay, just wanted to clarify.
Okay. Staff, could you please describe this note again? The additional note that you guys have drafted.
Yes, so I just want to clarify on the record that this note was established by both the applicant and by our finance department. They agreed to writing this note together. And it reads, the service plan being approved is the one shown in Exhibit 3.2 of the August 27th, 2019 BOCC staff report, outlining in the financial plan, which provides a maximum 50 mills for debt service. The operations and maintenance mill levy is limited to 50 mills until a debt service mill levy is imposed, after which an operations and maintenance mill levy is limited to 20 mills. A total maximum mill levy of 70 mills is permitted after the debt service mill levy is imposed.
Thank you very much. Commissioners, do we have any questions, comments, or do we have a motion that might involve this additional note? So could you go, how many, could you go to the screen right before this one? And the one before that. All right. So if this were to be approved, somebody could give a motion to approve with 9 findings of fact and a note, correct? All right. Do we have a motion?
Chair, I move for PLN 2019-9 Promontory Metropolitan Service District numbers with the approval of 9 findings of fact and 1 note.
Second.
We have a motion and a second. The motion passes 3-1. Congratulations and good luck. Thank you. Is there any more business? I think that's it. We are adjourned.
And County Manager, we're upstairs.